Justice Breyer, welcome to Stetson. Thank you for being here.
Thank you for inviting me. No, it's nice. The students are, look, I just learned 125 years old, right?
Yeah.
No, there isn't one person here who looks at 125 years. I don't even look 125 years old, and that's amazing. Okay, but thank you very much. It's really nice to be here and fun and interesting. And he said he had some friends. Now wait, he said he had some friends who've written some books. No, he didn't say exactly that. He said, I have some friends whom I like who have written books. That's important. That's important because I have written one.
Yes,
Okay.
Exactly. Well,
Thank
you. And so most of our audience tonight are law students. Many of them are in their first year and they're taking their constitutional law course. So I thought we could talk a little bit about the Supreme Court and how it actually works. So it is a court of limited jurisdiction. Can you talk a little bit about how cases come before the Supreme Court of the United States?
What do we do?
What do you do?
Well, yeah, that's a good question. First thing, I don't know how many of you are first year. How many of you are in your first year? Yeah, quite a few. All right, so you have to know this boring stuff, and this is the boring part because I want you to know. I want you to know what the cases are and how do we deal with them. Okay. First, have any of you ever had arguments with brothers, sisters, or families? Yes. Friends? Yes, you have. Okay. Now, have you gotten over them? Yes. Not all? Or you go into another thing. Now, there are probably billions of arguments in the United States, and almost all of them you get over it. Now, if, in fact, you cannot get over an argument, say it's a criminal matter, or say it's a lot of money or something, I don't know, or an accident or something. Or suppose you can't go over it, you go to a person and he's called a, who do you go to? No. This is a very important question. You might go to an arbiter eventually, but you go to first. Right, you got it. Okay, this is important. You keep this in mind and tell everyone. That's what you want. And you go to a lawyer, and the lawyer is supposed to help you out, and usually they do. I have to say usually, because but they do. They try to get the thing settled. They try to help you. Okay. Now sometimes, but very rarely, but sometimes they fail. And then where do you go? To the court, of course. But before you get to the court, you have to, what do you go up? The courthouse steps. And almost all the rest settled right there. So you never get inside the courtroom. But sometimes you do. And if occasionally you're there in the courtroom, now you might have a jury and you might have a judge. Okay? You will have a judge. But you might, and you'll be the judge or you'll be the jury. That's, by the way, what you want to know, because in the back of your mind is his question, David's. He said, how do you get on the Supreme Court? And the answer to that question is no one knows. There's only one person who gave good advice, and that was Tom Clark, who was justice for many years, and they asked him, how do you get appointed to the Supreme Court? He says, I have no idea, but I only know one thing, and this is true in a lot of things in life. I only know one thing. You have to be on the corner when the bus comes by. Okay? And I'll tell you this other thing, because now you're going to think, how am I going to be on the corner? And it might not be the Supreme Court, it might be some other thing. The best advice I got, I'm being stream of consciousness, but the best advice I got about what your next 2 or 3 years should lead to was from Bayless Manning, who was dean at Stanford. And I was thinking of teaching, was talking to him about it. He said, you know, you're going to make very important decisions when you're young. What are you going to do? What kind of lawyer will you be? Where will you work? Maybe who will you marry? I mean, terribly important. And for each of them, you're only going to know 3% of what you'd like to know. And there's no way to know more. So I can tell you a few things. Don't become a trapeze artist. Probably it is too late for that.
Yes.
But with that plus 3%, the advice he gave me, lighten up. You know, you won't make an idiotic decision. Very unlikely. And what will happen is you'll decide on the basis of your 3% and your legal training, and then your life will unfold itself around you. And you'll have some days that are marvelous, and you'll have some days that are terrible. And that's just what it is. And so lighten up. I thought that was pretty good advice. All right, now get back to the court. The court is what? We're in our courtroom, the district court, the trial judge, that's my brother.
Yeah.
He tells me nonstop the only people who know any law are trial judges and trial lawyers. I think that's a pointed remark that he makes quite often, but nonetheless. Okay, and the jury decides the facts, and what does the judge do? He sits there and tells the jury the law. And afterwards, one lawyer wins and the other lawyer loses, say. And what does the losing lawyer think of the judge? Yeah, that's exactly right. He's a real idiot. Does he tell the judge, you're an idiot? No. He says, oh, what? But as soon as you get out of the room, a little different. What does the winning lawyer think of the judge?
Brilliant.
No, he doesn't think of the judge. He just thinks he's a good lawyer. That's right. Now, the losing lawyer, though, can appeal. So he appeals. And you can keep going. Every appeal. And in California, I think here too, you have an intermediate court. And then you might go to the Supreme Court of California. And by the way, I tell this pretty often. I started with 4 billion arguments. I just made that up. But I asked Chief Judge Liakis of the Mass Supreme Judicial Court once, how many cases are there actually in court? And he said 16 million. Somebody looked it up the other day. It's really about 80 million.
Wow.
But I said to him, how did you know 16 million? And he said, I made it up. He said, but it turns out there are 40, 60 million cases, and not counting traffic tickets, actually. But who knows? All right, now, we in the Supreme Court, unlike most other federal courts, only handle federal issues. See, that's Congress and the Constitution. But the students don't believe this half the time. It's true. Almost all law in the United States is not federal law. It is state law. And if people ask me how much, I can make it up, and it's roughly accurate. 90%, 95%, somewhere in there is state. You want about business, you better know state law. You better know torts, state law. Criminal law, state law. There's some federal criminal
Property law, of course.
Property law. Property law has been state law ever since the 1800s, which was long before there were states. Okay, but all right. In any case, it's state law. So I say, you want to help your family, your friends? Oh, say the members of the federal legislators, members of Congress. Federal law is the most important. Ha, ha, ha. Yeah. No, it isn't. Yeah. You try to keep your house. You try to keep your land, or what? Yeah. Why is it I still remember from my law school best the springing, that's what we were talking about, springing uses and shifting uses? Okay, well, in any case.
We were just talking about Pearson versus Post.
That's true. Pearson, that was my first case that I read when I was in law school. Pearson was about some fox or something. That's right. All right, well there we are. Okay, now, wait, finally we get through our appeals to the federal courts. It could be the Court of Appeals or state courts in the highest court that's taken it in the state. There's only one left to go. How many? Maybe 100,000 cases there with a federal issue. Maybe 80,000, 90,000. It could come to our court. And of those, we don't have to take a case. Very few that we have to take, very, very few. Mostly up to us, what we want to hear. And now, what happens? Of those 80,000 or so, 8,000, 7,000, 6,000 each year say, please take my case. All right, what happens? We each have law clerks. 4 great law clerks. I love my law clerks. Everyone likes his law clerks. They're so nice, and they save us a lot of work, and they're really good. So we divide them. We have a pool, and about 30 or so law clerks are in the pool. And if you divide 30 into whatever the number is, you get about each week 5 cases per law clerk, and they will write memos. So on Wednesday, I get a stack of memos like this, and they've gone through the briefs. You know, there's one brief, please take my case. The judges below are idiots. They didn't say that, but they sort of.
They imply it.
They imply it. That's right. The other side, don't take the case. That's ridiculous. Yeah. I obviously won and was right. And don't take it. Okay, which ones do we take? Now, I get a stack like this on Wednesday. And those are the memos of the 150 cases of that week, approximately. Saying, please take our case. And I go through them in about 2 hours. Now, I'd like you to think the reason I can go through those 150 memos in 2 hours is because I'm a genius. No, that isn't true. I'd like to think it, but it isn't true. What I'm doing, what makes me able to do it, is as a criterion. And what I'm really looking for is, does it meet the criteria? And what is that criterion? The criterion, almost entirely, is, did lower court judges disagree about the holding in this case, the legal holding? What do these words mean? In a statute, a federal statute usually, or in the Constitution? What do they mean? Is there disagreement? If there's disagreement, they probably need us. There very rarely is disagreement. But if there's disagreement, they may need us because law should be across. And if there is agreement, why us? They're perfectly good judges. In our heart of hearts, we admit that. And it's true. And if all these judges decide the same way, who needs us? Okay, see what I'm looking for? Now, there are a few other criteria. If a lower court judge if they hold a law of Congress unconstitutional, we'll probably take it. And there are a few cases, Guantanamo or something, such a big deal case, we think the country needs our opinion. Ha, 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 ha. That's it, maybe. So there you have it. Now we take it. We took the case. How did we take it? It was Wednesday, remember? Thursday, the chief sends a paper around all the ones he thinks should be discussed Friday. On Friday, we're in the conference, just us in a room, big table. The 9 of us are there, and we go through the cert part, and the chief says the issue is da-da-da. We discuss them usually, very briefly, and you vote. 4 people take them. 4 votes takes the case. And if I think there are only 3 votes and we should take it, I might hold it over. Anyone can hold it over. Discuss it next week. I might write a memo. Okay, now you got that. Now we have our cases. Maybe 60, 70, 80 for the year. And we go along in our doing it week by week or every 2 weeks. Okay, now your case is taken. Now what do? Now the lawyer says, great. But he has to write a brief. And so what we'll get, see, we hear oral arguments in 2-week stretches. You don't have to remember this, but the first 2 weeks of October, November, December, January, last 2 weeks, February, March, April. And during the 2-week on, what happens is we hear oral argument Monday, Tuesday, Wednesday. Thursday, we think. And on Friday, we are in conference and discuss it. Okay, got it? But before, a week or so or 2 weeks before, I have all the briefs for that next week. And it's a stack. It's usually, there's a blue brief. That's the plaintiff saying how right I am. That's the petition. That's the appellant. I'm so right. And the other brief, the red brief, no, you're not. The yellow brief, yes, I was. And the yellow brief is the reply brief. I always read that first because it has the same arguments, but it's shorter. Yeah. Okay. And then we have the light green, which are all, you can follow one. Light green is the amici that's for the blue. And so you color code us in case we're sure. All right, but in any case, then the dark green are all the briefs. Anybody who wants to can file one, really, for the other side. Okay, so we have. Now, that means in a case, I will get probably a week or 2, maybe 3, before the oral argument, a box which will have maybe 20 briefs. And it could be 100. In that, I think the affirmative action case, I think there were about 100. Right to die case, we had about 80. We couldn't deal with all those if that were common. It's not common. It's usually about 15, 10, 15, maybe 20. Extreme. Okay, this time, 3 weeks before, 2 weeks, I read them. I really read them. Now, I can't say I pay total 100% attention to every one. If there are 20, but I will certainly start with that yellow and maybe go to the blue, and maybe it's the Solicitor General, the government. That's always gray. The government's always gray. I don't know why. But regardless, it is. I'll read those, and then I'll start going through the amici. If there are a lot of amici, I might pick out certain ones. And I'll know, I'll skim all of them at least. And I know from the table of contents, I know what they're arguing. If I see a new argument, I'll read it. And if it's certain briefs, I will read, because I know this is a good brief written by whoever. And eventually we'll get them all read. I'll read them or skim them at least and decide that they don't add much. And Now let's finish it. Then what? Then my law clerk, I tell her what to write, because these are the questions I don't know the answer to. You go look up what you can. And then you can add anything else you want. But I want that. And I'll get that before the oral argument. Okay? And so we'll sit down with the four and we discuss each one that we're going to hear in the oral argument. So look, I've read the briefs. I've got a memo. I've talked to my law clerks. I think I'm pretty well prepared for that oral argument. Everybody does about the same. Now we're in the oral argument. Half hour each side. And Rehnquist used to really enforce that. They don't enforce it so much now. But he used to. Half an hour, boom, you're finished. 2 hours, Monday. First hour, second hour, 2 cases. Half hour, half hour, half hour, half hour. But that oral argument's for me, for us, for the judges. It's not for the lawyer really to present his great arguments. I've read the briefs, you know, and if you had such a good argument, why didn't you put it in the brief? So it's questions, it's questions. Now, a good question, which isn't always asked, and I don't claim to be totally virtuous in this, but the best kind of question is, I don't know the answer. I really don't know it. And I think the lawyer knows more about it. Suppose a bankruptcy lawyer. How much do I know about that? All right. And how is it going to affect your profession? How is it going to affect bankruptcy? And sometimes, go look at the Second Circuit courtroom. Learned Hand designed it so there's eye contact. So we sometimes can get into this discussion. I didn't know the answer. I think it's going to help me with the case. And you get somewhere. That's useful. To go ask a question that, and I might ask a question that shows my colleagues where I'm coming from. That's useful. Well, okay. Asking a question to show I know more about it than the lawyer or a better argument than the, no, don't do that. You know, I get to decide the case. That lawyer doesn't. Hey, please spare me. There's no reason to ask such a question, in my opinion. And
can I just highlight one part of what you're just talking about? You're saying that in some ways, some of the questions are directed at other members of the court.
That's the point. I say that's useful. Yeah. That can be useful. I show them where I'm coming from. And then we are in conference, they know sort of, they see the kind of thing. But I might change. Does oral argument change? Yeah, it sometimes. Does it change you from A to not A? Rarely. But does it change how you see the case? Yes. And that's true in the circuits too. I mean, I knew that lawyer in front of me. Usually, if he's argued the case in the district court, he knows what this is about. And when I get him going, he'll tell me what he thinks is important. And I say, okay, now I see what he thinks is important. Probably it was. But you see, it's trying to help decide this case that you're asking a question. Telling a joke, I admit Nino did that sometimes, and I admit I did it too sometimes. Don't do it. The lawyer whom it seems to be, ha, 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 ha. The other one's, all right, so just don't do it. I can't claim I always follow that rule. All right, now we're finished oral argument. Thursday, we're discussing the case. Friday, we're in conference. We're sort of closing in on it. But I get to conference. The chief begins. He's down here. He says the issue in this. We each have a black book where we have everybody's name for each case. The chief will say, I think such and such. I think we should affirm or we should reverse because, and I didn't think the main arguments the other side were so good because, and that's maybe 5 minutes, maybe 10 minutes. And then it goes to at the end as we shifted. It goes to Clarence Thomas, then it goes to me, then it went to Sam Alito, and then Sonia Sotomayor, and Elena Kagan, and then finally towards the end, Gorsuch and Kavanaugh, and Amy Coney Bryant, and Ketanji. Okay?
In order of seniority.
Yeah, that's right. Nobody speaks twice till everybody speaks once. A very good rule for any small group. Yeah, true. Everyone thinks that he or she has been heard. Very good, very good. Now, after everyone's spoken once, and I've written down what they say, we go back and forth. Now, that depends on the personalities, how much you go back and forth. And it depends on what's said, and it depends on the case. But I can just say one thing about the 28 years I was there that I learned fairly quickly. If you start saying something after the 9, and the point of your remark is, I have a better argument than you, you don't say, but that's But if I have a better argument than you, hey, this is good for any group. You're going to get nowhere. Because all that's going to lead to is the other person thinking, no, I have a better argument than you. So stay away from it. And the thing that I found works the best, listen to what the people say and where they're coming from. And now try and take what they've said and where you think they're coming from and see if you can build on that. And see, maybe you reach a compromise. Maybe you get here. And that's always a problem, compromise, because when have they gone too far and when haven't they gone and when blah, blah, blah. That's true in any group that you're going to have as clients or anywhere. And I think it works pretty well. Listen, and then you build on what they say. Okay, now we're finished conference. There are tentative votes on everything. The chief assigns. He's not tremendously powerful there. Sometimes he is, but he has to follow certain unwritten rules. One, everybody writes one, everybody writes two, and everybody writes three. So you have to do it fairly, a fair division over the year. And then also, I learned how to get it assigned to me. If I want a case, here's how you get it assigned. I'm sitting last for 11 years. 4-4, it's up to me. You know, I have to be sure they assign it to me. I just say, I'm not sure. I did that once with a case I really didn't want, and I ended up writing it. I never said, I'm not sure again. I said, blah, blah, blah. Okay, but you see, because the chief has to assign in a way that's going to produce at least 5. I told Rehnquist that once. I said, I've discovered how to get 5 votes on a single opinion, finally. And he said, how? And I said, you start with 9. that's all right. But in any case, you see what he's trying to do? He's got to try to get that 5. Because nobody really cares about what I say is the Constitution or what Scalia says is the Constitution or what somebody. What they care about is what does the court say. And you don't have 5, you don't have a court saying it. And that is a problem. So the chief is really, he has some discretion there, but not too much. All right, if he assigns it to me, back to my law clerk, she'll go and write a draft, let's say, or a memo or something. Takes about 4 or 5 weeks usually. And I get this memo from her, and maybe it's the form of a draft. And then I said, I was a law professor. So what do you think happens when I turn around and see my word processor? I change the first word. Well, you change the first word, you got to change the second word, and then you change the third word, and there we are. And finally, I give it back to her, and she thinks hers was better, but nonetheless, okay, we have to go with what I think, and we discuss it, and draft, and finally we think it's ready for circulation. We'll circulate it, and all I want is a response, 2 words. I just want 2 words. I don't want anybody to say in their response, I couldn't care less. This is the greatest thing ever written since sliced bread or something. But no, I want 2 words. I agree. How often you get 2 words? Sometimes, but normally or more often you might get, I will agree if. You see? And that goes back and forth for a while. And then anyone can write a dissent, anyone can write a concurrence, and eventually everyone has joined. That's always the first thing in a conference. Is there anyone who hasn't joined these drafts yet? If so, when are you going to do it? Got to get this out. And when they finally everybody's joined or written, that's it. Goodbye. The next Monday it comes out, or the next Tuesday. No calculation as to when. When it's ready, it comes out. That's my experience, and it's ready as soon as everyone's joined or written. That's it. You are now experts. You do not have to go to your 19 more spring semester constitutional law class.
Thank you so much for that. I'm sure our Conlaw students are thrilled that you saved them so much reading time. A question about the Supreme Court's docket. When you clerked for Justice Goldberg, the court was hearing often 350 cases a year. Most recently, it's been in the 50 to 70 range. What accounts for the change, and is that a good thing?
No, my own view, people have views about it. The reason is, look, when you think when I was clerking for Goldberg, that was 64, 65. That's 10 years after Brown. Do you think those 10 years after Brown was being enforced throughout the country? Ha, ha, ha. That was a court with a mission. It was trying to get Brown enforced, and it was hard to do. And there were a lot of cases involving that, Heart of Atlanta, a few others, and some civil rights. And Congress was passing a lot of laws. Well, Justinian, The famous Roman Empire, I read this in Montaigne somewhere. The emperor, he thought judges were going off on their own too much, so he would have the laws written just the way he wanted, with lots of laws. And what Montaigne says is that man was a real idiot, because doesn't he know that every word in a statute is just grounds for lawyers disagreeing? Yeah, there were a lot of laws being passed. And when there are a lot of laws being passed, there are a lot of words. And the job of appellate judges, normally, and certainly the Supreme Court almost entirely, is taking words. There are some words, either in a statute or in the Constitution, and the question is, do those words apply here? If so, how? What do they mean? What's their scope? If it says policeman, does it mean German policeman too? Or English, or just American policeman, or what? And so those are legal questions. A lot of words, a lot of questions. A lot of new statutes, a lot of questions. A lot of new cases, for example, all of segregation, a lot of cases. And Sandra used to sit there, Sandra O'Connor said, we've got to take more cases. Which ones? What? I didn't usually think we were taking too few, but that was my opinion, because I didn't know which. And the lawyers, of course, they say, but there was this terrible conflict. Oh, there was? Well, we have my law clerks and me and the statute and everything. I didn't think it was really a conflict. Which one? So we didn't take it. And so I don't think there certainly is no effort to take fewer cases. And I mean, sometimes you might, with a case, I mean, we find examples of that. High political content. Not much of a legal issue, don't take it. You don't have to.
Right.
And so there's some of that, but not too much.
Okay, thank you. One of the things we really pride ourselves on here at Stetson is teaching advocacy and writing. What are some of the characteristics of strong advocacy, both in the oral and written format?
Well, it's my brother you have to ask.
Yeah, right.
I mean, he's the one who
He's
knows.
the trial judge.
Yes.
Right.
And it's interesting. Roberts was a very, very good Supreme Court advocate. Yeah. It's actually a rather specialized thing, because you have to get your main point out in very short time, so they'll remember what it is. And then you have to deal with the point that's your weakest. And then, because this is your chance, because your case is not as good as your stronger points, your case is only as good as your worst point. And that's what you have to do. You have a little time for that, and then you have to answer their questions. And I got the best advice on that when I was being confirmed. Mike Berman took me around. He was sort of the Sherpa taking me around the senators. And what he told me, I've kept in my mind, and you all know this because you're going to be good trial lawyers. And what he said was, you sit there, don't try to show them that you're so clever. That's not relevant. Now, what is relevant? I think it isn't. As I've gone through many, many years, I think the key criteria for being a judge, I said, Dianne Feinstein asked me this once. What do you think is the main thing we should look for? I said, it's something you won't know the answer to. You can't. It's what you should look for, but you can't get what's the person's character. That's what it really is, I think, most important. But anyway, skip that. You want to know how to argue the case. Answer the question. That's what Berman told me. He says, you're not there to show how clever you are. You're to get confirmed. A senator, and that's intimidating, I'll tell you that. You think it might be intimidating arguing your case. No, it isn't. Go sit with 17 senators on the other side and a television camera. God. and that's right. They'll ask a question. Answer it. Don't answer it immediately. Think what you want to say. They can't make you say this immediately. You can take your time. But think what you want to say. Answer the question. Answer the question completely. And don't go into some other question that you like better. No. Answer it. Then he'll go on to the next question, that senator. And then the next one. And eventually he'll run out. And then the next senator will come along and he'll do the same thing. And eventually the last senator will come along and do the same thing. And when he finishes, then you will be confirmed. That's not as easy as when I was confirmed. That was in 1994. But still, it's quite a lot. And there's quite a lot, as you know, with a witness, or quite a lot with a trial judge, and quite a lot with the Supreme Court. Answer the question. you know. And if the judge, you can't do anything about this, but the judge is trying to show she's cleverer or he's cleverer than you are because he knows all these things and you're wrong because that's his problem. He shouldn't. I think he shouldn't. I think the point of a question is not to show you know. After all, he has to argue it. I get to decide it. All right, that's good enough. And you want to write something in your opinion, fine. But your oral argument is to find out things you don't know, not repeat things you do know, from the judge's point of view. Okay, so we write it. You now know how to get the timetable, and now you can argue in the court if you want. John Roberts was wonderful. You never knew what his own view was. He was repeating the view that you had on this side of the case. And what's his name? Who was the SG? I'm forgetting names now. He's the SG when George Bush was there.
Paul Clement?
Yeah, Paul Clement. Yes. Very good. And Olson, what Olson was great at was rebuttal. He gets 5 minutes rebuttal. And my God, he would come up with things. Amazing. But it's a very interesting opportunity, if you have the opportunity to argue in the Supreme Court. And I hope you do. But being a trial lawyer in general is very interesting.
So let's talk about your most recent book, Reading the Constitution, Why I Choose Pragmatism, Not Textualism. So why do you choose pragmatism?
What's pragmatism? Pragmatism actually, in the title, is a word my publisher made up. I didn't suggest it. I mean, I think there's a traditional way for a judge to deal with what these words mean. I don't like mean either. I don't like that as a word because that's a famous philosopher, Wittgenstein. He said that. He said, don't look for the meaning, look for the use because nobody knows what meaning means. Okay, so I say what helps is you do often ask, what's the scope of these words? That is, if the word is policeman, does it include a German policeman? Sometimes it might, depending on the statute, but usually it wouldn't. And you want, what does it apply to? Where? What's the boundary? Okay, you have that kind of thing quite a lot. Now, what was your question again?
So
that's why I retired.
So let's talk about it. So in your book, you contrast.
Oh, in the book, yeah, okay, got it. Right, we're back to the book.
Textualism to pragmatism.
No, I know the book. I know the book. Believe me, I know.
So let's do let's do the first half of the book about textualism, and then we'll do the second half of the book on originalism.
Now, this is what I think, but it may not be true. But I do believe it. That there's a traditional way for an appellate judge to decide this question of the meaning or the scope of the words, or what they apply to, what they don't apply to. And that's true of the Constitution, too. This is, after all, where does it have it here somewhere? Here, yeah, this is, it's a very short document, but a lot of words. And where do they apply? What do they mean? And when Justice Black says, oh, just read them, it says, Congress shall pass no law abridging the freedom of speech. And he says, no law means no law. I say, okay, fine, no law, that isn't the problem. The problem is with the words, the freedom of speech. What is their scope? I mean, do they apply to every? I mean, what? I mean, what's the boundary? And there's the problem. And there are ways of going about interpreting those words or any other set of words. What? Well, you read them first. That's what Portalis, who is a great French, do any of you are going to read French law? No, nobody. Okay, but you might go to Louisiana. They have a very good civil code based on the French art. Regardless, Portalis, who was a great scholar of French law and really wrote the French civil code, he said, of course, you read the text. And when the text is clear, you follow the text. But he added, the text is never clear. Indeed, why is it there in the Supreme Court if it was so clear? So there are ways. In the 18th century, there are some historians over at Stanford that looked into this, and they say, and I think it's true, in the 18th century, one of the major questions a judge would ask after reading the text, of course you read the text first, is, well, what's the mischief that Congress was after? What's their purpose? What were they trying to do? And I myself, I worked in Congress. I used to write these reports for our committee, the Judiciary Committee, and we'd send them to everybody, and their staff people at least would read them. And if they didn't agree, they wouldn't agree. They could write something separate, or they could tell me and might change it. Okay, but you see, what's the purpose of this statute? What's it after? What's Congress trying to do? And what about the consequences? If you decide it this way, what's going to happen? You don't know, but you might have an idea sometimes. Or if you decide it that way, what will happen? You look at that? I think, of course, you look at that. You don't want to do something ridiculous. And what about the values? Okay. This document was an effort to get certain values that this country would take as fundamental. Yeah? Democracy, human rights, equality, rule of law, work together with other countries, etc. They're in here. And they're also in the air, even if they're not here. We know what's better and what's worse usually. And so are values relevant? Of course, in my opinion, of course. And so I say that was when I was in law school. I learned what? Who were the judges who were respected? Hobbes, Brandeis, Cardozo, Learned Hand, etc. Okay, fine. I say that's the traditional system. That's what I mean by pragmatism. And the textualists, what they think, I mean, you can see how they might think it. But what do they think? They think the Warren Court went too far. And I used to debate this with Nino. We'd go to college, went to Lubbock, and it was a great debate discussion. And they'd come away, they had it in the football stadium. The students must have thought there was going to be a football game. Because they listened to us for a while. It was obvious to them that we liked each other, that we were friends, that we got on well, and we had different points of view. So, what do the textualists think? In my opinion, I'm not really a textualist, so you can't take what I say as absolute, right, by any means. But I think they worry about the Warren Court, not the part about race, but that they went too far, that Brennan went too far, for example. So I'd say to Nino, I'm not Brennan. He'd say, I know that. and he said, but when they, for example, have tort suits, it says nothing in the Constitution or the statute about that, the Bivens actions or taking the first 8 amendments and applying it to the states. It doesn't say anything about that. And Brennan just would make up what he thought was good. He thought it would be good to be just like Sweden. They might think that. Maybe it would be good. I don't know. But we're not Sweden. Okay. So they say the thing that will help here, it will help stop the judges from substituting what they think is good for the law is to have strict rules. And the strict rules will be, follow the text. If the text doesn't tell you, we'll make other rules. They're called canons. Canons. They did a survey of what staff people in the Senate knew any canon. Most of them knew one canon about don't try to decide a constitutional matter if you don't have to. But they didn't know it. Robertson, I wrote a dissent in a case he wrote where he referred to the reference canon. I said, the reference canon? What's that? But anyway, I don't want to criticize them. I'm not criticizing. I'm trying to say what they think. They think we can use canons. We can make other words. We can stay away from purposes. Stay away from consequences. Stay away from values. Just try to read it linguistically. And they think, 1, that will be easier. 2, it will mean the law is more uniform across the country. 3, Congress will like it because they'll know how the cases, how their law will be interpreted. And 4, it will stop judges from substituting what they think is good for the law. Those are the 4 main arguments that Nino used to make. And okay, that's the textual. And originalism, well, you read this, it says something like law, freedom of speech, too abstract. What do you mean? How's it going to help you reading that? And they'll say, take the words to mean what an ordinary person at the time they became part of the law thought they meant. He said, he has a rule there. You see? And you do that, it'll do the same 4 things. It's just a branch of textualism. We will then have more clarity, more simplicity, and they'll not substitute their own judgment. That's the argument on the other side, roughly. And I think Gorsuch, who holds that very strongly, who was a friend, and we used to disagree about this, and he knows we disagree, and we do. So, okay, so what? And we can talk about it. And there we are. Is that good enough?
That's fantastic.
Okay.
For this argument about that originalists argue, one of the virtues of originalism is that it constrains judges from imposing their own view of the good.
That's right.
You, I think, disagree with that.
Yes.
Can you expand on why a little bit?
Well,
more?
the example that I use to explain why I disagree with it is Dobbs, where I dissented. It was the abortion case. Because I have an imaginary conversation with Sam Alito, who's a friend. In my imaginary conversation, he wrote the opinion. We, as the dissent, if anyone, those who read it will understand, we felt rather strongly about it. And so in my imaginary conversation, I, a dissenter, asked Sam, who wrote the majority, I said, well, why did you decide to overrule Roe, which has been the law for 40 years, and Casey? I mean, what is it about them that makes them appropriate to haul out from 40 years and overturn? Is it that you chose that because they got to their result in Casey v. Polino and in Roe without using originalism or textualism? Is that why? Of course it isn't why. And he wouldn't even claim it was why. Because after all, if you said you're going to overturn every case or re-examine every case that doesn't use textualism or originalism, you'd have to re-examine 90% of the U.S. reports. I mean, nobody used it before a few years ago. But so he won't say that. I said, well, why then? Well, he said, I said why. It's egregiously wrong. I said, oh, I see. You think that's why you overturned it, because it was egregiously wrong. Now let's think about this generally for a moment. You are criticizing me or Brennan or some other person for substituting what they think is good for the law. But you can substitute what you think is egregiously wrong or not egregiously wrong or right for the law. Now there may be a difference there, but it's what Paul Freund said, the minister said to the woman who asked him after the sermon, what's the difference between the cherubim and the seraphim? And he said, there used to be a difference, madam, but they made it up. Okay. So I said, yes, what's the difference? Right, exactly. You got the point. So I think that on the, anyone can be not a great judge if you want not to be. But judges are supposed to follow the law. And in the cases in the appellate courts that are difficult, you don't know what the answer is at the beginning. It's hard to do, but you're trying to find it. You're going to keep down your personal feelings to the extent you can. No one can jump out of his own skin. No one can deny the life he's led. So they creep in and so forth. That's true of everybody. That's true of everybody. You see?
What does the structure of the Constitution have to do with interpreting it from your perspective and then maybe your originalist colleagues?
I'm not sure. I mean, the structure, I haven't thought about that. It's a good question. I mean, the structures, it's mostly about how to set up a federal government.
Right.
And then you have basic rights and it's lasted. And when I talk about it from my point of view, well, see, I think with the textualism, the originalism, I mean, really, just look at the text, please, spare me. I mean, we have here's one case, it's the easiest one I could find on that. You know probably that if, in fact, you have a child that has a disability, handicap, something like, so the school board has to provide a special education, help them. And if you think they're not doing a good job, you can bring a lawsuit. And if you win your lawsuit, the statute says you get your costs. So the case in front of us, which was a real case, does cost include the woman won, the school board lost, and now she wants her costs? Does that include the $29,000 she paid to an educational expert? Is that part of the cost? So I say imaginary to Nino. Let's see, is the educational expert part of the cost, or is it just legal costs? Or is it just filing fees? Or what is it? You say, look at the statute. Okay, I'll look at it. It says cost. Okay. You say, really look at it hard. Okay. Cost. Several times, cause. All right, where am I? I say, please spare me. And you say, which is true, that sometimes those House reports, Senate reports on the bill are just made up for various political reasons and don't really, well, you don't have to use those things. If you don't have help, don't use them. If you think they're help, use it. It's not determinative. It might be a factor. You see what's going on in the House or the Senate or that world at that time might help. I don't say use it. I say use it if it's helpful. And it's going to be more helpful than cause. All right, that's basically the argument. And people come out different things. And what I'm going to write now, what I'm writing on, is what I fear is if you just use linguistic things, you get further and further away from what I learned from my jurisprudence class. See, some of those classes stay with you. Don't tell the students that, but they do. And what I learned was Hart and Sachs, and Sachs said, look, law in general, what they've written about in legal process, it's designed as an institution. Law is an institution that in general, not everyone, but in general should help people live together peacefully, more peacefully, productively, more productively. That's a general kind of an aim. And we have a certain kind here of a way of living together. And we've had some terrible experiences, slavery, civil war, segregation, all kinds of god-awful things, but we're together. We're still together. And the 340 million people live together. Not always agreeing, I guarantee, but they live together. And so law has a function there. And you get too far into this linguistic stuff, which I'm for, of course you look at it. But you get too far into it and leave out other things that are more directly related to human life. Before you know it, the law itself will have taken it, particularly if it's the Supreme Court, will have taken it away from human life. You take it away from human life, and people, they're not going to die or anything, but they just won't pay that much attention. They just are less likely to pay attention. They're just, perhaps from the narrow court's point of view, they may be a little bit less likely to pay attention or think important or think a critical part of government is the judiciary and the rule of law. And we don't want that, because a rule of law, I can go into that forever, but I mean, a rule of law is what we depend upon to keep those 340 million people together. And it's certainly one of the things we depend upon. And it's certainly important. So I don't want to see them move in this direction. It's all a question of risk, but I think the risk of the divorce between law and life increasing is a bad thing.
In your last chapter of your book, you talk about paradigm shifts, mentioning there was the Lochner era, then the New Deal court, then the Warren court. And you argue both ways about whether we're going through one now.
Yeah, I don't know.
Share your thoughts on that?
Yeah, I was too optimistic, I think, in that book. I thought that this whole thing of the textualism, originalism, forgetting about what the human factor is there in terms of the law that's designed to help, I thought that'll fall of its own weight. I probably thought that too much. It might not. It might not. So I say, what are the risks if it doesn't? Well, I've told you one of them that I think is pretty important, and that is the risk of an increased divorce between law and life. And I can't say you just do whatever you think is good in the circumstances. You don't. That's what's called law, bringing it in. It's complicated. That's why they have to be here for 3 years. And you said they must pay you or find some finance more than $43,000. I heard you. And why? Because it sort of prepares you. It doesn't teach you everything about law. But I mean, I always thought that in law school, when you're teaching, you say, oh, you're teaching how to think like a lawyer. Ha, ha, ha. What I think it really is it's just like doctors. You know, doctors have to spend that first year learning the name of every bone in the body. And I say, there's a lot of law out there in property, in contracts, in torts, in everything, business law. You have to get a basis for it. And then you're ready to go out and help. I say the great thing about law school, why be a lawyer? I tell the undergrads this. I say, because it's a good profession. Why? Not always good, but usually. Why? I say, because it requires both head and heart. Everybody has a heart, but not everybody has a head. And so here you are, you see, and you use both, and you get the opportunity to use both and to be helpful. And sometimes your cases will be great, and sometimes they'll be terrible, and there we are. But it's a pretty good profession, so I'm glad you're here. I hope you are.
You were alluding to this a little bit earlier, but the process of judicial confirmations in the Senate, especially in the Supreme Court, has become increasingly fraught. Do you have any thoughts on whether that direction is going to continue and whether there's anything that could be done to reduce some of the tension in that process?
Yeah. Will it continue? I don't know. And who knows? You want to go talk to all the senators? That'll do you no good. When I did work in the Senate, we used to have, if we were trying to get X through or stop Y or something, we'd always have two strategies. This is Senate staff we're talking about. One strategy is, who do we talk to on the inside on the staff or among the senators that maybe Kennedy have some influence with or was superintendent. But the other, which was the more important, is who in this senator's district is a person that senator relies on. It's the outside part. I mean, they're very sensitive to what people in their district or their state are thinking. And if they weren't, they wouldn't be in that job for very long. So the people to talk about and convince are not so much the senators. I say the people to talk about, to talk to understand where they're coming from, to discuss with them the constituents. And that's what I tell the students. I say, I want you to vote. You have to participate. Don't go and sit there and think, because I'm not getting my way, I'm just going to go look at a movie. People don't even look at movies anymore. They just look at streaming on television. But I looked at movies. They really were good in those days. but in any case, that's who to talk to. And I think that makes a difference, a big difference. And of course, I can criticize the senator. That means nothing. I say, asking me, I was not a person who was a senator. I worked in the staff. I was not the person who voted to confirm anybody. I was the person who was confirmed. I was not the person who nominated anybody. That's the president. I was the nominated person, the confirmed person. So asking me about the confirmation process is like trying to discuss the recipe for chicken a la king from the point of view of the chicken.
Fair enough. Speaking of your time in working in Congress, do you think that experience affected your judicial philosophy and approach as a judge and justice?
Yeah, absolutely. I mean, two things. One thing that affected me most, I think, is what Kennedy, I mean, you don't know what it was like working there. At first, I would not work in the Senate on the staff in this. I had tenure somewhere else. That's a big risk there. But nonetheless, you want a little experience. But Kennedy was wonderful to work for. I mean, he was fun. He was fun. I don't know about what he did away from the Senate, whatever it is, but with his staff, he was great. And what he'd tell us almost immediately is, look, do not try. Did I tell you this just now? To get credit for stuff all the time. If the thing works, there's plenty of credit to go around. If it doesn't work, who wants the credit? Look, credit's a weapon. So what you do, and I tell you, you're not the first group I've told this to, but the one that moved me the most, I think, were seventh graders. Because you try talking about law or anything else to the seventh graders. You might get any introduction you want, even with very nice one like that. But still, no, they're looking out the window, okay? And so somebody will say, well, what should we do about the Constitution? I say, I don't know about this document. Yours, it's yours, you know. That sort of attracts their attention. I say, you're the ones that I have to see this works. And then, but I say, I want to tell them what Senator Kennedy said. He said, we're having a hard time getting something through. Here's what you do. You find a person who you like, decent person, who believes sincerely that you're completely wrong on this. And then you go talk to that person. Wait, don't talk too much. Listen, get them to talk. And eventually, in many, not all, but many, many instances, they'll say something that you honestly and really agree with. And as soon as they do, if they do, and they often do, as soon as they do, you say, what a good point. You have. You have. What a good point. Let's see if we can work with this. And then you try to work with it. And maybe you get 30% of what you wanted. Good, take it. Don't sit there and hold out for 100% so your friends and followers and everybody can say what a genius and great you are because you stand up. No, you want to get a result. So you try. Take that 30%. And I heard him so many times when we occasionally did get something, and the press would be asking him, well, Senator Kennedy, somebody would say, you did such a good job on that. And he would say, don't thank me. Thank Orrin Hatch, the Republican, who came up with the idea that brought us together. Now, what interests me about that, which I've told you and repeated, is when I tell the 7th graders that, or the high school students, they've left the window. They're sitting there and they're listening. And I like the look in their eye. And the look in their eye, maybe I'm making it up, but the look in their eye tells me they're going to help. They like it. They want something to do in this divided country. They want something to do that will help bring us together. And they can do that with their own group of friends or whatever, but they have something to do. And so I say it to them at the end, I hope you participate. You participate, because I don't know everything or even much about this document, but I do know if you don't participate, it won't work. And I hope you at least vote. And if we want anything more on that, I say what I read Derek Bach write somewhere. That Pericles, in his great funeral oration in Athens, 2,500, 2,300 years ago, something like that. And he's extolling the virtues of democratic, which is somewhat democratic, Athens. He says, what do we say in Athens? What do we say about the man who does not participate in public life? Because we do not say, this is a man who minds his own business. We say, this is a man who has no business here. Mm-hmm. You say? You say? You like that? And I might tell them something that meant something to me. You finished college, you did a little reading and so forth. It's worth reading some of those classics. I went a year or two ago, I had my first chance to go to Athens. And you sit in Athens for a lawyer. You go there, and if you've read a few classics, I've read a few, you sit there in the hotel lobby, outside, sun shining, you look up and there's the Parthenon on top of the Acropolis. There it is. And what do you think if you've read Orestes, or Euripides or whoever, Aeschylus? I don't remember who it was. But nonetheless, at the end, in the Eumenides, I think, he has, you see, Orestes has killed his mother, who had killed his father. It was a tough world at that moment, not good. And but he's being tried. And Athene comes down. Who is Athene? Athene is the goddess of justice. And she gives a wonderful speech. She gives a speech which says, no, we're going to have a trial. And she has a jury. It's split and she votes his innocence. But regardless, that isn't the point. The point is, before that, we saw in the earlier plays, it's back and forth, revenge, revenge. That's the Eumenides. The Eumenides, that they're the gods of revenge. And she, first of all, sends them to the basement. She sends them to the basement. Doesn't kill them, doesn't destroy them. They're there, but they're not powerful and don't govern the retribution. You see? Vengeance is being substituted for Athene. So you think that when you see it. And that's why we have a profession. Okay? That's why you're here. That's why we're in law school, or we do what we do in justice or law. And so that's worth remembering. Vengeance is in the basement. And it's Athene who says how the rule of law, juries, maybe even judges, lawyers, they're going to be in control.
One last question for you. If you could unilaterally enact one amendment to the United States Constitution, what would it be?
My father, this is his watch. It says Irving Breyer, Legal Counsel, SFUSD, San Francisco Unified School District, 1933 to 1973, from his friends. I kept that. After he retired, in the San Francisco City Charter, which was a pretty good charter. It said in 73, 40 years after it went into effect or something, we're going to have electors to come and change those parts that should be changed, bring it up to date. Right. Okay, so he was elected. Very surprised. He goes to the first meeting, comes home that day. How was it? He says it was terrible. Everybody has his favorite, and they can't agree about anything. And that happened in Chile fairly recently. If you've been following, I don't know why you wouldn't necessarily mind. The Chilean is an interesting government, and they wrote a new constitution. It was voted down because everybody went to the meeting and voted their favorite things. So I've stayed away from answering your question because I don't necessarily have a favorite thing. And if I did, why wouldn't everybody? And if we, no, it's okay. It's pretty good. What is this document? And what I say about my wife said to each of our grandchildren, 2 are too young, but we have 7, and the other 5 got, well, I will pay, she said, I think $20 to any of you who memorize the Gettysburg Address. And several of them did and got the money. Why? Well, think of that address. Think of it. You say 77 years ago, okay? That's back to the Declaration of Independence because the word equality was not here in that document then, but it was in the Declaration. 77 years ago, our fathers set forth upon this nation a new continent, a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. We are now engaged in a great war to see whether this nation or any nation so conceived and so dedicated can long endure. That's the part I want to have remembered always. Why? Because it's an experiment. That's what Lincoln was saying. And I found a letter that Washington wrote where he said the same thing. See, a lot of this is based on the French and the Scottish, Lumiere, and those Lumieres are like college professors, and I can say this being one. They know everything about all these great ideas, they have all these great ideas, but they think nobody but them can actually make them real. Ha ha, say Washington, Lincoln, and the others. Yes, we can. Yes, we can. We can make this experiment work. So what I want people to see, I think it's true, is we're still in it, my friends. We're still in it. We're in it. We're in the experiment. And we have to see now that it works. And that's our, I think, a primary mission for you as it was for me.
Justice Breyer, thank you very much.
Thank you. Good. Thank you very much.
Thank you, sir. Great conversation.